everyone. So I hope that you've been having a good CPDP so far. My name is Hannah Draper, and I'm a program manager in the Open Society Foundation's information program. And I'm very pleased to be here today on this panel discussing a new project called CyberBRICS, which is being launched by FGV based in Rio, Brazil. And the program is being developed in conjunction with the Higher School of Economics and Center for New Media and Society in Moscow, the Center for Internet and Society based in Bangalore, India, the Fudan University in Shanghai, the University of Hong Kong in Hong Kong, as also in partnership with Research ICT Africa and the University of Cape Town. So the goal of this project is to look at data protection and cybersecurity to map existing regulations, identify best practices, and then develop policy suggestions for moving forward. And the goal of this is to leverage BRICS' commitment to the coordination of universally accepted norms of international law to ensure, in their words, a peaceful, secure, and open digital and internet space. So it's my pleasure to introduce to you today, in the order of the BRICS letters, the panelists who will all be talking about recent developments and their insights into these issues. I should mention that everyone on this panel has a bio that is probably interesting enough for a panel of its own, but I'll just stick to the germane facts. So first we have Danilo Doneda from Brazil, and he led the public consultation on the Data Protection Act there, which was passed into law in August, of 2018. Moving on to R for Russia, we have Alexey Tolvanov. I hope I've pronounced Ivanov, excuse me. Great. And he works on projects that use competition law and intellectual property in the context of digital economy and artificial intelligence. So now we have India, which is Elonnai Hickok, excuse me if I've said it wrong. And she is the COO for the Center for Internet and Society. And she works on issues related to privacy, cybersecurity, freedom of expression, and artificial intelligence. So she's going to be sharing insights into recent developments in India, right, particularly to do with data protection and the right to privacy. Next, we have Marcelo Thompson. And he is a professor at the Hong Kong University in law and technology. And his recent research is looking at tech platforms, including conceptual interdependence of privacy, personhood, and law in the context of China's social credit scoring system. And now we have Ian Brown, who will be talking about South Africa. He is a senior fellow with Research ICT Africa's Digital Policy Project, and he's focusing on cybersecurity, data protection, and human rights. He's also going to be a visiting CyberBRICS professor at FGV in Rio in the coming May, I believe. And lastly, that takes us to Dr. Luca Belli. He's been the leader of this project, and he formerly worked for the Council of Europe in internet governance, and now he is a law professor focusing on internet governance and regulation. And his research focus areas are internet access, data protection, and looking at digital platforms, the regulation of digital platforms and digital policy in the BRICS countries. So with that, I will pass it over to Luca, who is going to moderate this session. Thanks again.
Thank you very much for the extremely precise introduction. So a couple of words for you to understand why we are here, why we are launching today this discussion, and why is it relevant, and also to understand why it is not only an interesting academic exercise, but a very relevant political and legal exercise that have potentially an incredible impact to analyze how BRICS are shaping their data protection and cybersecurity frameworks. So, as you all know here, BRICS are the home of 3.2 billion individuals. So the next billion individuals that will come in line will mostly come from those countries which are amongst the most populated in the world. They are elaborating they have elaborated over the past couple of years, with the exception of Russia a little bit before, data protection frameworks that therefore are going to impact the life of 3.2 billion individuals in the world, so that is 43% of the world population, and of the businesses that want to operate or being created in this almost half of the world. So the choices they are making and they are going to implement will have a tremendous impact on how data can flow around the world and how users, individuals can enjoy their rights, and how businesses can develop their strategies and their own businesses. What is very interesting, and I think the panelists today will give a couple of elements about this, is also the way in which the different BRICS, which are not a geographical entity. It's a group that was created by an acronym from a Goldman Sachs economist, but they have in common that are going, according to provisions, to shape the evolution of the world economy, the world demography as well. And we see very different ways in which data protection has become something key for the policy and the politics of BRICS. In Brazil, it has been almost 8 years of consultations, political scandals and revelations, the Snowden revelation, the Cambridge Analytica revelations, that then led to the approval of the privacy data protection law in August of last year. In Russia, it's the only BRICS member that is also a member of the Council of Europe, and therefore there has been more an international push towards the adoption of the harmonization of a legal framework that could be compatible with Council of Europe Convention 108. But interestingly enough, then after having approved this law in 2006, the Privacy Act, in 2014 it has been amended with some data localization provisions that are particularly controversial. In India, since 2017, with the Putsawami case, the data protection, privacy is a fundamental right, and this has led to renewed interest on data protection. And a draft bill has been proposed last year, and it's going to be implemented and discussed in the upcoming year. In China, although many people only consider the cybersecurity strategies and aspect of China, there has been incredible development on data protection, the elaboration of a data protection standard, the elaboration of guidelines that are framed in the context of cybersecurity and that are going to be implemented, shaping how people can do business with China, electronic business with China. And last but not least, we will see South Africa, which has already, it's a very interesting case because it has adopted already a law in 2013, but the law is not in practice yet. So the only part which has been put in practice is the creation of a regulator. So without further ado, I will let Danilo, starting with the B of BRICS, start with some insight on what has been happening in Brazil over the past years.
Thank you, Luca. Thank you, Hannah. About Brazil, which, as Luca mentioned, is the B for BRICS, I would start by trying to much quickly giving you a preliminary panorama, considering that in the case of BRICS, we have several countries with different cultures, different legal systems, different institutions, and it's worth going a bit ahead beyond the legal comparison of data protection enactment in all these countries, and considering I mean how the legal formats were developed in society, how did that protection emerge as a need in each of these countries, and how society and institutions dealt with it. In Brazil, we had, as Luca already mentioned, 9 years of debate on a draft bill, which has just been enacted into law. But parallel to this, we shall consider that since the 80s, Brazil has been trying to develop some particular vision of data protection, privacy protection, which at some period of time seemed to form a kind of starting point for a legal model on data protection in Latin America. Brazil introduced in 1988 in its constitution the idea of habeas data, which was taken by several other Latin American countries as a starting point, a legal format of several legal improvements that in some countries developed into autonomous data protection legislation, such as Argentina and other countries. Strangely, in Brazil, data protection haven't evolved into real data protection legislation. Also strange, Brazil has a particular, let's say, dynamics in developing data protection regulation than other Latin American countries. It's sufficient to say that Brazil has just enacted its first data protection law, which will have data protection laws in Latin America since the year 2000. And as of now, most of Latin American countries have their own data protection statutes. Why Brazil took so long in a way? Maybe because Brazil has a strong internal market, it doesn't need to provide for strong safeguards for international transfer of data before the time came. There are several situations that can make up for this. Maybe consumer law was enough to deal with some of the major problems regarding to data protection. And maybe Marco Civil Internet, the Internet Civil Rights Framework, which was enacted into law in 2014, tried to address some issues regarding data protection, and for some that could be enough at to some point. But in fact, none of these initiatives were general data protection legislations, as in the standards that we are seeing some convergence on the international level on the issue of data protection legislation. We cannot identify a general data protection regulation in Brazil, except for some that argued that maybe Brazil was standing for something similar to the States, where you regulated privacy through consumer privacy and through consumer protection bodies in a way similar to FTC. But the thing is that Brazilian legal system and Brazilian institutions are formed from European continental law heritage, and it's very difficult, if not impossible, to apply some institutions which are typical of common law countries in Brazil. It's natural to introduce a legal framework based on GDPR in Brazil, much more than trying to make people understand how a kind of North American legal system works in order to implement something similar to that. In the sense, as I mentioned, in the last 9 years, we saw things changing a bit. In 2010, the first draft bill was submitted to a public debate. In 2016, the bill was sent from the government to the National Congress, and 2 years after, in 2018, the Congress and the Senate approved unanimously a general data protection law. It was an interesting case of convergence with other legislation. I believe the enactment of GDPR played a great role in making more comfortable to people, and I mean especially private enterprise, to recognize that that was a model to be followed and not something that Brazil could not fight against. There was also the bid from Brazil to join OECD, which took important role on this, on the government decision not to postpone the adoption of data protection legislation in Brazil. But anyway, Brazil is in this first data protection law, and the country doesn't have, let's say, a tradition and a culture of data protection, which made some parts of the law being a bit unfitted to, in comparison to international standards. Let's start to say that, for instance, the law which was approved and enacted in 2018 created a DPA, an independent DPA, but the president later, when at the time of its enactment, vetoed some parts of the law, and especially the DPA. The DPA was vetoed by the president, and on December 27, an executive decree was issued modifying several parts of the data protection law and creating a DPA. This DPA, which was created, the National Authority of Data Protection, is an internal body of the direct public administration. It is located inside the Presidency of the Republic. It has a body of 5 directors with fixed terms, but it doesn't have financial nor budgetary independence. They depend for bodies of the Presidency of the Republic for all their needs. The executive decree mentions that the DPA have technical authority, but it's yet to be seen how it will be built, because the body of public servants are supposedly a part of the body of servants of the same Presidency of the Republic. So it is not yet decided how the composition, the details of the composition of the DPA will be worked on, even because the executive decree has yet to be approved by Congress, and the Congress has 100,000 days counting from today, 1st February, to decide on this. So it may change something or not, but anyway, the DPA, which was proposed, which was created by the federal government, is not an independent DPA. It has weaker powers than the DPA, which was approved by Congress and firstly enacted into law. For instance, a very important power, such as the power of audit enterprises, is lacking for the final version of the law. There are several changes in the law, also in matters related to the transfer of data between the public and the private sector. The executive decree makes it very simple to transfer personal data from the public to the private sector, and Council raised also some transparency provisions on this. Well, in the sense, in the next months, most probably the discussion will still go on in Brazil. Brazil has gone far, but in this year, several most important things about the final shape of the DPA and of the General Data Protection Law are yet to be decided, and it will be an interesting time to see how it fits inside other BRICS and international standards.
Thank you very much, Danilo, for this presentation. And actually, it's very interesting to see that although a lot of observers have hailed the approval of the law as something extremely positive, before cheering the approval of the law, one has to see how it will be implemented and how the details of the law will be specified and by whom. And those are details that are not yet clear at all. So it will be very interesting to evaluate over the next year. So now we go to Russia, and we'll see what is the current framework, what are the institutions that are behind it. And please, Alexey, go ahead.
Thanks, Luca, and thanks for having me here. I would start with kind of putting a broader framework of what's going on in the BRICS context, and I think there is also an issue what is BRICS and what does constitute this kind of alliance or club, which was more appropriate way to say about this. But this type of club is kind of naturally necessary for the current global architecture, I think. So, of course, it was created as an abbreviation by some sort of investment wealth managers or investment like advisors, but in principle the world does need some sort of third type of center for legislation, for rulemaking, for global guidance or global governance, if you want. And this type of things, they existed for many years, many centuries actually, in the course of global governance development. And now we turned into a stage when we do need to create a kind of alternative vision and sometimes alternative solutions for global governance. And if we would have like other countries combining this type of club, so BRICS could combine different letters basically, or different members, whatever, but the concept of developing world having a platform and developing world which has potential and has resources to enact and basically advocate and advance its agenda, its own agenda, not the agenda imposed by dominant powers, and those dominant powers by basically just US and EU for quite a while. And now we see this need and request for alternative solutions. That's what BRICS actually stands for. And although there are different discussions within BRICS whether it can exist in this format for quite a while, or would it have to change itself, but still there is a certain demand for this type of institution to establish alternative solutions for the world. And that's where there is certain value, both in academic sense and also in terms of like practical creation, establishment of new alternatives. And that's why I think this CyberBRICS project is very valuable as a methodological instrument. And now, if you follow BRICS Summit's kind of agenda, so normally they say about BRICS Plus, and Chinese were quite advancing this new concept of other countries also engaging with BRICS Club, and so being part of this narrative for alternative solutions. And now I'm turning to Russia as a case, and I think Russia is an interesting example of institutional experimentation, and in all possible senses of this meaning of this word, because for quite a while, as you knew, we were like a beacon of alternative vision for social order and economic development, which was like a communist socialist type of framework, and the world was divided into camps. And then we turned into quite aggressively neoliberal capitalist formation, where all sort of wild capitalism phenomena existed. And now we kind of in soul-searching process, looking for a way we have to advance further. And that relates not only to a bigger like macro level of political and economic situation in Russia, but also to more practical and technical aspects of certain legal areas like data regulation. And in data regulation, we see a little bit schizophrenic approach on the state level, on the government level, which combines two contradicting objectives and two contradicting trends, I would say. One trend is to protect what is understood as being national security thing, and basically trying to control the turnover of data and basically dissemination of data, and control primarily from the point of view of competition with global powers, with global players, which could be not only state players, but also transnational corporations, and you know, who are most active in the sphere of data collection and processing. But also at the same time, there is a perception that we can build our own kind of major players in this area and kind of national champions. And at the same time, this national security concerns and regulations which imposed on economic agents with regard to protecting national security seriously deters development of those national champions. So in this schizophrenic debate or schizophrenic situation, I'm using kind of a hard word for this, but I think it pretty much describes the state of affairs. We slowly like moving, so from one extreme to another, and right now I think we're closer to understanding that we reached certain limits in using national security argumentation for you know, advancing of data protection and data collection, data processing rules. And there is a kind of more clear, more visible desire to liberalize the area. And I think at this point, at this kind of stage of development of our legislation in Russia, we have pretty much advanced in terms of black letter law, legislative laws like related to personal data and some other areas of data regulation. Many of those acts, they were imported in a way, like copied from other advanced jurisdictions. But on the other hand, the implementation of the laws is pretty much right now defined by these needs for national security, sovereignty concerns, and protection. So. At this stage, I think Russia is moving towards the direction to find another way to regulate data. And the most interesting part of it is the debate about liberalizing regulation, protection of data, so that Russian companies, primarily like big major firms, which do have exposure to global markets and which can compete in the global markets and have the potential to compete in global markets, they could get easier access, more lenient kind of regulation to be introduced, so that they can get a better local, domestic, let's say, a base for collecting data, processing data, and then competing using those opportunities in the country for playing in the global field. And this debate is still ongoing. We have about actually a number of initiatives recently introduced by the government. The most noticeable one is called digital economy for Russia, and that's a phrase which implies actually a number of initiatives, and one of those is legislative initiatives. So there is a group assembled by the Skolkovo Foundation, which is a development institution. I'm affiliated, and I was working for a number of years as a director for policy development and legal initiatives at this institution. So under the auspice of this Skolkovo Foundation institution, we have a number of groups which focusing on improving Russian regulation so that we can establish enabling framework for competition. Yeah, I have just 1 minute, so I have to wrap up. In my perception, and I would think it's more like personal view, the other types of initiatives which are not EU-based initiatives or US-based initiatives are extremely not just I mean, they really necessary. There is an imperative. So we would have debate about how we structure regulation of data, because regulation of data is a global issue and a global phenomenon. And countries which do have resources to compete, because majority of, let's say, developing world, they do not have any resources. And if you see like Africa, except South Africa and some just very few countries, they primarily like feeding ground for global corporations, and they have to play under rules of this leading domino global powers. And what we see in terms of like trade negotiations, in terms of building international framework, we see a lot of efforts through promotion of so-called e-commerce, and under this concept of e-commerce, there is a very established trend of promoting liberalization of access to data, and through this access to data in developing world, you really can basically empower already established and dominant firms in the world. So to reframe the global framework, you need other centers of power and legislation and centers for rule making. And I think BRICS Club could be one of those platforms.
Thanks. Thank you very much, Alexey, for this overview, and also for stressing that the link between data protection, competition, and the potential to stimulate local business, and also the current undergoing trend to, as data, personal data, are the most valuable assets of already established corporations, to have a true scramble for data in Latin America, in Africa, or in Asia, in order to put their hands on the already existing data producers and harvest them and make good use of them. I mean, for instance, for cognitive services that are usually trained on Caucasians' faces and not on Latin American or African or Asian faces, it is an essential asset to collect data of populations of those countries. So the BRICS have indeed a role to shape a different narrative and different kind of regulation that may be perhaps more convenient for the developing world. Elonnai, please go ahead.
Oh. Sorry, how do I did something.
We should try to reach this to have another presentation. Can we have it? It's Elonnai.
Yeah. It's just
No, that's one. The other one? The other one? No, not that. Sorry. We have only 3. Is it this one?
no.
Is it
It was just there and we.
Is it in the pen drive? Or?
Is it the white one?
It's supposed to be there. Pen drive is not here.
I guess we do not have the...
Yes, open the file manager. The file manager. Yes.
There we go.
There.
We tried to be strategic and put it all in one pen drive. It might not have worked so well.
Yes.
Okay.
View full screen.
View and then full screen.
Thank you very much.
Perfect. Thank you.
There we go. Okay, thanks, Luca, and thanks for having me on this panel. So CIS began researching privacy in 2010, and I thought that perhaps I would start this presentation by giving a little bit of national context and pointing out some of the factors that we saw driving the privacy discourse and still driving the privacy discourse in India today. So first off, India doesn't have a comprehensive privacy legislation, and it has a history of conflicting case law on the right to privacy, at least until up to 2017. It has quasi-data protection standards found in its Information Technology Act under Section 43A and associated rules, as well as select provisions in sectoral law that speak to different aspects of privacy, such as found in like banking legislation, etc. Aadhaar, India's digital identity scheme, has been driving the debate around privacy, as there's concerns that the scheme violates an individual's right to privacy. There's been a strong industry voice involved in the discourse around privacy, particularly around EU adequacy, as India has a strong and large IT sector. Adequacy would, of course, help that facilitate that trade. The right to information. So there's been concerns voiced that the right to privacy might supersede the right to information. It was a hard-fought-for right, and it's very important in the context of India. And then also the Digital India flagship project of Modi, and it's essentially e-governance scheme and turning a number of different e-governance initiatives going digital with them, has also kind of been driving the debate around privacy as well as state surveillance. So here's a timeline of kind of some key different policy aspects and developments that happened with privacy in India. So in 2010, we had an approach paper to privacy. In 2011, the rules under Section 43A were enacted or notified, and that frames or forms the data protection framework as it is today. In 2011, there was a draft privacy bill. In 2012, there was a petition filed in the Supreme Court challenging the constitutional validity of Aadhaar and the fact that it violates the right to privacy. In 2012, there's a Justice A.P. Shah report that came out with a framework for privacy and data protection in India. In 2016, we saw the enactment of the Aadhaar Act. And in 2017, we had the Alford Judgement that Luca referred to, which recognized privacy as a fundamental right in India. And then in 2017 also, there was a Shri Krishna committee established by MIET. And in 2018, that Shri Krishna committee came out with a draft data protection bill and an associated report. And then in 2018, we had an Alford Judgement. And now in 2019, we have an amendment to the Alford bill, or Alford Act. So I'm going to focus now on the Puttaswamy judgment. It read the right into Article 21, which is the right to life and personal liberty. It overturned 2 judgments that held that privacy was not protected by the Constitution. It noted that it protects the individuals from the state and non-state actors. And it really looked at privacy as a right with multiple dimensions, including spatial, informational, bodily privacy, as well as the right to autonomy. And importantly, it held that any exception to the right to privacy or violation of the right to privacy has to meet a 3-pronged test, that being the existence of a law, that law should not be arbitrary, and the infringement of the right by such law should be proportional for achieving a legitimate state aim. So after the Shri Krishna committee was formed, they came out with the data protection bill, and I thought I would just touch on some of the interesting aspects and kind of key aspects of that bill. So the scope extends to the public sector and private sector, and this is a shift away from what we have right now in Section 43A, which extends only to body corporate. It extends to PI and SPDI, and importantly, it expanded the definition of SPDI to include transgender status, caste or tribe, religious or political views. This type of data is not protected right now under 43A of the Information Technology Act. It created data fiduciaries instead of data processors, and a recognition that data processors have a duty of care and common good towards data individuals, or yeah, I think data principles is the right word. And then it also creates 2 categories. So you can have a data fiduciary as well as a significant data fiduciary. And that significant data fiduciary is determined based on its size, the amount of sensitive personal data it might be processing, if it's using emerging technologies, etc. It created 2 levels of consent, one for personal data and then one for SPDI, or sensitive personal data. It laid out different grounds for the non-consensual grounds, well, for processing of data. It incorporates 4 rights: the right to access, the right to correct, data portability, and the right to be forgotten. It created different kind of alternative forms of accountability that I thought were interesting. So if you're a significant data fiduciary, you have to undergo data audits. You have to incorporate privacy by design into your everyday workflow. And then you can also, based on the data audit, be given a data trust score by the Data Protection Authority. It does have data localization mandates. This is 2-tiered. So for personal data, there has to be a serving copy stored in India. And then the bill also enables the government to define critical categories of data. The critical categories aren't defined in the bill, but essentially those critical categories of data have to be stored within India. Then there are 6 exemptions. It establishes a DPA and an appellate tribunal, and which can, if a complaint is taken to the appellate tribunal, it can then be appealed with the Supreme Court. Now, I think, kind of building off of what Alexey was talking about, kind of this new way or a new form, the Shri Krishna report that accompanied the bill is actually, it's a very interesting read, and it tries to approach data protection from a global south perspective. It proposes a 4th way of doing data protection that is very distinct from the US, the EU, and China. Some of these, I tried to call out a little bit of what's in the text, but so for example, instead of the right to explainability or the right to object that we see in the GDPR, they say that accountability is a more effective way to achieve the same end. It talked about consent dashboards as a way to address consent fatigue, though consent dashboards didn't find its way into the bill itself. And they also talked about this notion of community data developed by communities that receive specific protection. Community data also didn't find its way into the bill, but I thought it was a kind of a new and different idea from what we've traditionally seen coming out of EU and US. So then quickly on the Alford Judgement, essentially the Alford was, the constitutionality of Alford was challenged in the Supreme Court, and the Supreme Court did hold it to be a constitutional project, but it said that private entities can't require or mandate your Alford number. And so what this means in practice is that, like, for your mobile connection, you don't have to give your Alford number, or to get a bank account, you don't have to give your mobile or your Alford number. Then these are some examples of emerging trends and projects, and I thought they were kind of interesting to just juxtapose against what we saw with the data protection law and the right to privacy, but the different ways in which data is being envisioned in its use in India. So there's a quote for the public credit registry, which is being developed by the Reserve Bank of India. It says, in an emerging economy like India, it is always felt that the smaller entrepreneurs, mostly operating under the informal economy, do not get enough credit as they are informationally opaque to their lenders. And essentially the public credit registry is trying to bring together different data points and create a 360-degree picture of someone seeking a loan. In the National Strategy for Artificial Intelligence, the report talks about India positioning itself as a kind of an AI garage for the global south, which I thought was interesting. And then there's a proposed national health stack, which tries to create a backbone of health data that can then be innovated against. And so I think you see a lot of initiatives trying to bring together, consolidate, and leverage data for innovation and different purposes in the country. So key issues that we see kind of on the horizon, of course, are the data protection bill, if it's going to be passed. We heard that it'll be tabled in June, but let's see. Data localization. The provisions in the data protection bill for data localization raised a lot of controversy, but it's not the only place that data localization has showed up. There are mandates in the financial sector in India for data localization, as well as proposed requirements in an e-commerce policy. Cross-border access to data for law enforcement purposes. I left out law enforcement there, but I think is a big issue, and the MLAT process is broken right now, and I think it's an important issue in India. Surveillance powers, innovation, and how to harness data for innovation, and of course the digital governance agenda. And well, this is my last slide, so I only have 1 minute. That's good. But essentially, I wanted to share this quote because I thought that it kind of called out the different challenges that all BRICS countries are facing. And to me, it was kind of exciting. Well, this project is exciting because there are a lot of commonalities, and there's a lot of different ways, different ways the countries are approaching it, but also similar ways that the countries are approaching it. And I think there's a huge space for research in this area.
I mean, actually, there is really a desert of research with regard to BRICS digital policy, and that is precisely why this project could have been interesting to develop. And I really like this very last concluded thoughts, because actually BRICS challenges are common to all developing the whole developing world, and there is also the potential to leapfrog part of the problems and of the mistakes that sometimes that have been done by more developed countries over the past 20 years to create something different. And it is something that I think many of the BRICS countries are trying to do by themselves. And I think China, to have a segue to the next speaker, Marcelo, is a very interesting example, because it is not It is not only it has not only created a very interesting cybersecurity law, but also the specification with data protection standard and guidelines are very interesting and will be very impactful. And on the parallel level, they are also implementing the credit social scoring system that Marcelo will speak about. And this is really a very concrete case of how what we are speaking about is put into practice, and what are the overlap and the interference or the downstairs.
Try pressing F5.
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 Should. So if we can have someone that does it for us, it would be helpful. Otherwise, as we are stuck behind the table. Okay, excellent. Thank you. Thank you very much. So the China one, please.
This one. Just
this one.
In the bottom, there is the presentation icon. Just press that on the right, bottom right.
No, right.
In the toolbar of
In the gray area.
at the bottom, sorry, the status bar of PowerPoint.
Yes, we are almost. You're almost there. Oh, a little bit on the left. A little bit on the left. Go on the left. No, no, less on the left. No, on the right, right,
Next
right.
one, next one. Yeah,
This one.
That one.
No problem. Thank you. So Marcelo, please go ahead. Excellent. Perfect.
Is this working? Yeah. All right. Thank you, Hannah and Luca, for the introduction and for having me. I'm Brazilian and I live in China, so this project speaks to my heart, because I can reconcile two different worlds, two different interests and passions that I have. But today I'm only going to be talking about China. But I'm also going to be talking a little bit about Hong Kong, just to set the scene for us to begin our discussions. So I'll try to rush a little bit with the earlier part so that we can have some time to discuss the social credit system as well. So I want to present you with the evolutions of data protection in China, but also to this thing which is developing on the side of data protection, which is the social credit system. So we tend to think of comparing China and Hong Kong. Hong Kong is the liberal society, right? And we would imagine that Hong Kong would have a very strong data protection regime. And what I would like to argue here is that that is really not the case. Just to give you a background, Hong Kong is a special administrative region of the People's Republic of China. There is a principle, which is the principle of one country, two systems, that Hong Kong is part of China, but it has a different legal system. So that there is one country, there are two different legal systems. And in our basic law, in Hong Kong's basic law, it is recognized that Hong Kong will continue to practice after the handover in 1997, the capitalist system and way of life. It would continue to practice the common law. It would have its own scientific and technological standards, which sounds a bit naive, but that's what our basic law says. It's a very laissez-faire economy. Finance and property are the main drivers. And this has a result on how our data protection landscape has developed. So though we have the recognition of several privacy interests in our basic law, though we have a Bill of Rights recognizing the right to privacy, when we go to actually applying that, which is our personal data protection ordinance, we have a very weak regime. We have a sorely outdated regime that dates from 1997, and it was amended in 2012, and we missed a very good opportunity to brought it up to date. Not with what would become the GDPR or anything like that, but even with the directive, with the data protection directive, because not even at that level we are. So the PDPO binds government and private actors. That is good. It recognizes a number of data protection principles. But when we go to scrutinize what these principles mean, what they say, we see the following. Consent is not required for collection in Hong Kong. You don't need consent. As long as you're collecting the data for a purpose which is connected to the functions of the data user, you can collect, even without consent. Of course, when you collect directly from the data subject, you need to inform the data subject. But when you collect indirectly, so when it's inferred data or when it's data from, that you acquired from a third party, you don't need to inform the data subject. So there is no requirement of information for indirectly collected data. We don't have anything like a requirement of legitimacy with regard to the purposes of processing. There is no purpose specification principle in Hong Kong. Though the purpose needs to exist at the time the data user collected the data, the purpose doesn't need to be really specified at that moment, let alone informed when it's situations where you're inferring information. Our data protection authority cannot award damages or fines. We don't have a provision on transborder data flows in force, which means that the data can leave Hong Kong. And as a result of that, our data, PCPD, or Privacy Commissioner, understands that platforms are not data controllers. They are not data users in Hong Kong if the data is stored somewhere else, because they just cannot control. So it's a very weird landscape that we have with regard to data protection in Hong Kong. As you go to China, you would imagine, right, that a communist society would have a much weaker data protection regime, right? But that's actually not the case. You have an ongoing development in the data protection landscape that though China doesn't have an independent data protection authority, so you have some competition between different parts of the government enforcing this landscape, you do have some principles which are much sturdier than the principles we have in Hong Kong. So what is this regime? I'm going to skip the historical introduction so that we go directly to the provisions. But just one point to note that there is traditionally a fluid relationship between the public and the private in China that stems from a Confucian tradition. So values of self-cultivation guide private life as much as public life, and there is an overlap there. But there is a growing understanding that there is a right to privacy. And this public sentiment has been reflected in recent legislative developments. So the criminal law was amended in 2009 to create an offense of selling or illegally providing citizens' personal information. The tort law, we have a new tort law in 2009 that includes the right to privacy amongst the rights whose violation gives rise to tort liability. There was an amendment in the consumer law recognizing a number of data protection principles, and importantly, a requirement of consent. Which is also reflected in the cybersecurity law of 2016 that also recognizes a number of data protection principles and requires consent for the collection and processing of personal data. Now, this cybersecurity law has been specified by a personal security specification that has been issued by the Information Security Standardization Technical Committee under the CAC, the Cyberspace Administration of China. And this specification recognizes very strong, very powerful principles, which we're going to be seeing now. The specification is non-binding, but it has an authoritative role coming from where it comes. And it's likely to be, and it's already being followed by regulatory authorities. You already have cases of enforcement, even against companies like Baidu, Alibaba. It establishes a GDPR-like framework. It's a very encompassing set of principles and provisions that is very akin to what we have here in Europe. In theory, it specifies the more general provisions of the cybersecurity law, but actually in practice it goes a bit further. It goes beyond the cybersecurity law, and there are challenges then in this regard. Whereas the cybersecurity law is not very clear with regard to whether it applies to the public sector, the specification makes it clear that it encompasses both the private and the public realms. And whereas the cybersecurity law concerns network operators, the personal information security specifications go beyond that. So there are a number of basic principles. The responsibility needs to be commensurate with the harms. There is an idea of commensurate responsibility, which is interesting, enables a certain scaling of responsibility, whereas the GDPR will talk about comprehensive responsibility, right, of the data controller. There is an idea of commensurability that enables a certain scaling and understanding that some actors should respond, right, according to more stringent standards than others. Right? There's a requirement of a clear purpose that also needs to be a lawful and legitimate purpose, a requirement of consent for the collection. Okay, so a number of different, I was a bit ambitious here in my timing. A number of different requirements and exceptions to consent that don't exist in the cybersecurity law are present in the specifications. So in cases of major public interests, or as necessary for signing and performing a contract, as it is the case here in the EU as well, right? You don't need a consent. Consent can be inferred, doesn't need to be explicit consent, but for personal sensitive information, the consent needs to be explicit. A number of other areas, including automatic decisions, also are included in the specification. So it's a very encompassing set of provisions. It's very interesting and much stronger than what we have in Hong Kong. Okay, I think I'm sure there will be questions, and I don't think I'll have time, unfortunately, to... Just very quickly. I'll just say something very quickly about the social credit system, right? I cannot let you go without saying something very quickly about it. So the social credit system, we tend to imagine the social credit system like the nosedive Black Mirror episode, right? Something which is dystopian and people rating each other, is a frivolous system, right, with no public values embedded in it. But I would argue that actually the social credit system is the antithesis of that. And it has been widely criticized. And if we understand the social credit system indeed as an authoritarian regime to oppress the citizens, to rank them, to give them a unified score just to induce them to behave in a certain way, right? Uniform way, there is no diversity. If that is really the case, right, then I think we can criticize it widely. But it's also important to see what the different features of the social credit system are. And I'll just say very briefly, just focusing on the bottom there, that there is an idea in the social credit system of also protecting the rights and interests of credit information subjects, of social participation, involvement of natural persons in the development of the system. And also, it's not something that applies only to the citizens. It's something that also applies to the government. It also applies to public officials. So public officials are also subject to the system. And this creates, together with possibilities of social participation, a certain opening up. Now, is this going to be applied like that? Right? We have in the planning outline and in the guiding opinions by the State Council, everything explaining this as a set of values which underpin the system. Is the Chinese government really going to live up to these values? As long as the system is really going forward, what we should expect, and we should hold them to, right, is that we should have something like that, right, developing. A system where government sincerity is also very important. They say it's the crux of the social credit system's construction. If that is really going to be the case, right, that is something different and special that I think deserves to be studied and approached also from a more granular perspective. And also the idea that the system is not only a platform for punishment, it's also a platform for rewards, for nudging people and encouraging them towards behaving in a way that reflects certain values that we treasure, that we cherish. But I'm more than happy to discuss this later on. I'm already beyond my time, and I'll pass the mic to Ian.
Thank you very much, Marcelo, to highlight what may be counterintuitive, because actually people, I think, out of China would think that Hong Kong may have a more progressive framework than China mainland, but actually it's the contrary. And also for providing this alternative vision of the social credit system, which is usually not what people have out of China. It's also true that people out of China do not know well China. So I think the interest of this project is also try to contextualize what kind of political and regulatory decisions have been made by the governments over the past years, and try not to. What we promised ourselves was to start without no preconceptions, and to try to unlearn what we had in our heads about how the different countries work, in order to analyze and learn effectively how things work and why things have been shaped in a certain way. And I think the Chinese example is I think an example of also of mistrust, maybe led by ignorance in the purest sense, meaning not knowing what happens in a certain country. And I think one of the goals of this project is indeed to try to understand what is an objective narrative, not a narrative influenced by other external observers. And with this, I will ask Ian to finalize with what is happening in South Africa.
Thank you very much, Luca. It's a pleasure to be here. Just as a very brief introduction, because I think as several of the speakers have already done, to South Africa. The research project I'm working on this year with Research ICT Africa is looking at Africa as a whole. Although obviously, Africa is an enormously diverse, culturally and economically continent. South Africa, according to the always useful CIA World Factbook, is a middle-income emerging economy with an abundant supply of natural resources, not so relevant to data protection, but what is that South Africa has well-developed financial, legal, communications, energy and transport sectors, a stock exchange that is Africa's largest and among the top 20 in the world, and Africa's GDP by purchasing power parity is 30th in the world. So obviously South Africa is the richest economy in Africa, and at sort of one end of this scale. Let me briefly, so we can maximize time for discussion, point out some of the key features of the South African legal framework to privacy and data protection, both in the constitution, in the, as Luca said, largely yet to be commenced horizontal Protection of Privacy Act, but there are some specific sectoral protections relating to those key industrial sectors I just mentioned, and tell you about recent developments. So I won't go, obviously I've got a lot of text on here, and I will try to tweet my slides later so you can look up the details if you want, but I'll just point out some key points from each of these legal frameworks. So in the post-94, post-apartheid Republic of South Africa Constitution, which is a very modern and progressive constitution, has an extensive Bill of Rights as Chapter 2 of that constitution, covering both the more traditional civil and political rights that I'm sure you're all familiar with, but also as well a range of economic, social and cultural rights. Section 14 of the Bill of Rights, the right to privacy, some sort of traditional, more traditional perhaps conceptions of privacy, protection for the home, property, possessions, but also specifically privacy of communications mentioned there. I said it's a broad Bill of Rights. It implements both at the UN level, the International Covenant on Civil and Political Rights, and that is something that apart from China, the other BRICS have all ratified. So that might be one area that, one point of comparison for all of us here. Actually, the EU Charter of Fundamental Rights, which is from a similar time frame, I'm sure those of you familiar will know it also includes a very broad range of civil, political, economic, social and cultural rights. And in the debate about privacy, of course, it's not only privacy as a right, privacy also implicates other key rights and supports, and equally is supported by equality and dignity rights, which are really core, for obvious reasons, to the South African post-apartheid Bill of Rights. Freedom of assembly, association, expression. The Constitution also, in its interpretive sections, specifically says that the South African courts should consider international law that South Africa is a party to, including the ICCPR, and optionally also foreign law. So, as other Supreme Courts do, I think less explicitly mentioned in their constitutions, but certainly the US Supreme Court, sometimes the EU Court of Justice, certainly the UK courts, will sometimes look at other nations' legal provisions if they're relevant to the discussion. Obviously, they're not binding on them. You can see the very broad Section 36 part of the Bill of Rights there, saying that the rights may only be limited in similar ways to some of the other countries we've looked at. There must be a law of general application. The limitation must be reasonable, justifiable in an open and democratic society, taking into account dignity, equality, freedom, and so on. And also, interestingly, enforcement is very important, as Marcelo was just saying. In practice, do you have a strong regulator? Do you have strong private rights for individuals or for groups? We're having that discussion in Europe as an optional part of the GDPR. The UK, for example, has chosen not to allow group actions under the GDPR, but that's part of the South African constitution, that groups and associations may take action. In terms of horizontal protection, there has been since 2002 a slightly, to European eyes, unusual act, particularly relating to electronic communications and transactions. It only contains voluntary principles. However, companies may choose to sign up to these principles in whole. They can't cherry pick the principles. In some ways, it's like the EU-US Safe Harbor and then Privacy Shield Agreement. US companies can choose to sign up to those principles, but then when they do, they're enforced by the FTC, in theory at least. As Luca said, there is this charmingly named POPI, Protection of Personal Information Act, mostly not yet in force. It was actually drafted based on an early version of the GDPR, so it looks very extensively actually like the 95 directive with elements of the final GDPR, including accountability, including legitimate interests as a justification for processing personal data, including what the GDPR calls data protection officers. POPI calls information officers, including a requirement for breach notification. However, unlike the GDPR and its interpretation, there's no right to be forgotten. There are no explicit data protection impact assessments, although let me come back to that. There's no right to portability. Luca already said most of it is not yet in force, and I'll talk about that right at the end. I won't go right through these, because you can see there's quite a few specific sectoral laws relating specifically to telecommunications, to do with interception, sharing of data about telecommunications customers, particularly licensed telecommunications companies. I mentioned finance is a big sector, so there are specific client confidentiality provisions in the two acts you can see there, although allowing disclosure on a more open basis than something like GDPR would. Health data, of course, very sensitive, and specific acts about patient confidentiality. Under POPI, the information regulator, who is the authority, the DPA equivalent from GDPR, may approve sectoral codes of conduct, but that has not yet happened. And so finally, the current status is, in December 2016, the information regulator members, so the chairperson there is Pansy Tlakula. There are 2 further full-time members and 2 part-time members have now been appointed. They published draft regulations under POPI in September 2017, and then consulted. That consultation took much longer than is foreseen under the Act, but they've just published final versions of those regulations, which specify mainly quite sort of administrative details, such as forms that people can use to object to processing. The reason, supposedly, the reporting in South Africa, I'm not saying this based on any insider knowledge or conversations with South African politicians or regulators, but the argument at the moment, apparently, that has stopped POPI being fully commenced is to do with how it is paid for and how the Treasury classifies this regulator. When that happens, which is expected to be this year, that 2002 Electronic Commerce and Transactions Act will be repealed, and organizations will have 12 months then to comply with POPI. If you want to find out more detail, I've listed some resources there that I've found useful, and please do interact with us on Twitter. Thank you.
Excellent. Thank you very much, Jan, for the very detailed presentation. And now I guess there will be questions or comments. If you have any questions or comments, just raise your hand, and this gentleman over there will bring it. Please, there's a gentleman here, and then, okay, please go ahead.
Can I just interrupt? We're losing Brazil. Don't worry, it's not symbolic, BRICS.
I will represent Brazil.
Okay, I was going to say we have other Brazilians. Thank you, Danilo.
Thank you.
Ciao.
Ciao, ciao.
Please, go ahead.
So I'm Stuart Dresner from Privacy Laws and Business. My question's about Russia. It's been reported that Roskomnadzor is thinking of imposing sanctions on Twitter, maybe, and another company on grounds of data localization. So can you give us a bit more information on that?
Yeah, I think it works. Yep. Thanks. Yeah, we do have law which requires companies which operate in Russia and collect data from Russian customers to store those data in Russia. Sanction for non-compliance with this law is pretty much straightforward. So you could be blocked in terms of access to Russian customers. And they imposed already this sanction on LinkedIn. And LinkedIn doesn't work in Russia, although it works through VPN services of all kind. Actually, Roskomnadzor for quite a while didn't enforce heavily this provision because of sort of failed practice with LinkedIn. I mean, it didn't really work fully as a blockage. They didn't build a great firewall of like in China. Yeah, so they didn't manage to do this, or they didn't want to do this, and then it was a long discussion whether we have to proceed with this rule or not. And then Roskomnadzor started to basically negotiate with big players and ask them, maybe you comply with the law like voluntarily. And actually, I was quite surprised, but Facebook did decide to comply voluntarily and moved its data storage into Russia. Then with other companies, Microsoft did comply to a certain extent, Twitter did not, and so they now kind of starting to basically threatening them again, also not imposing this, not using this sanction. And we had a case of last year which was a kind of highlight of Roskomnadzor efficiency, I would say, or inefficiency, which was actually a block of Telegram. And that was very kind of shameful thing for Roskomnadzor, because they announced everywhere that Telegram will be blocked. It was a different type of rule they didn't comply with. Actually, the rule was related to access to cryptography keys, basically, which supposedly should be submitted to the authority, so that the authority would have technical access to correspondence in the messengers. And so most of the messengers, by the way, complied. And they did provide these cryptography keys. Finally, Telegram also submitted something, but Roskomnadzor was not satisfied, saying like it was not those keys, we were asking for different keys, blah, blah, blah. It was a long discussion. And finally, they decided, okay, let's block it. But I can use Telegram in Russia, and majority of people do use it. And so it's still there, it's still working. A little bit slow, much slower than it works here, but still it's operational. So I think if you take my perception on what's going on right now, I think it's another attempt by Roskomnadzor to prove its efficiency by basically using, you know, this war beats, or how to say, drums, you know. They using the drums saying, oh, one day we will block you. But they basically negotiate for voluntary compliance. Would they so the ultimate question is whether this type of failed practice would lead Russia, us, to implement a type of Chinese approach to defending, or let's say, you know, carrying out Russian cyberspace from the global cyberspace. They do have technical capacity to do this. They already allocated some resources for this. They did not yet decide whether it's a good solution or bad solution. So I would consider most of these discussions between Roskomnadzor and big firms as a kind of way to test the ground, whether it's a good, not, I mean, how we can, so it's a little bit like still negotiation process. Yeah, thanks.
Can we take some other comments here?
Thank you very much. Thank you very much for the interest panel. I would like to play the role of a devil's advocate maybe for a bit. I understand that the general idea of the panel is to show that there can be different approaches to data protection. My first question is, can this raise an issue with cross-border data transfers if there are different rules to data protection in different countries, because it may be difficult to assess adequacy of such rules? And my second question is probably more general. Is it really efficient to have different approaches to data protection in different countries? Because, for example, if I run an internet business which is accessible to everyone who wants to use it, it is easier for me to comply with data protection rules if they're the same everywhere. And if there is a situation where a specific country, say Russia, for example, has particularly burdensome regulations such as data localization, as a person running an internet business, I may decide not to enter this market at all, rather than to comply with this particular and burdensome regulation. And in the end, it is probably the consumers in Russia who lose. What is your opinion on that?
Can I provide a quick reply, just because I mean, you targeted the reason behind the project. So I mean, just to remind that, I mean, the rationale, the objective of the project is to have a triple purpose, meaning mapping what exists that already is very good and useful, because a systematized mapping of the regulation in practice is something that doesn't exist and would be maybe extremely useful for, not only for researchers but also for investors, governments, and users themselves. Identify what is working well, so good practices of approaches that are particularly efficient to achieve the purpose, and then put forward some suggestions. So the ultimate goal would be to, after having mapped and identify what works well, to propose some elements that may provide synergy or legal interoperability amongst the blocks of the BRICS, meaning elements that allow people not only to enjoy the same level of protections, but also business to invest and have juridical certainty, foresee what are the rules, and having more or less homogeneous rules of the game. It is an ambitious goal, but I think it is feasible if you consider the official statements of the BRICS over the past at least 2 or 3 years, and also the creation of partnerships on science, technology, and entrepreneurships. So it is the official statement of the BRICS to harmonize and to synergize their frameworks. Then my read is also that these things do not happen also because there is really literally no one proposing how to do them. There is no one analyzing, doing this kind of analysis and proposing how those goals could be achieved. So in spite of having official commitment from the highest leaders of the BRICS in this direction, then you have no proposal on how to do so. And that is the kind of gap that we aim at bridging. I will then let my fellow panelists reply to you in a more detailed fashion. So please.
No, it won't be in more detail, but just a very quick point. I think there are issues of values as well, and in a certain cultural, I wouldn't say just relativism, right? But different cultural contexts. If you take something like the social credit system in China, right? Are you going to have that in the EU, right? It's just like difficult. I understand that GDPR is an amazing standard, and I think it inspires the world. I think everyone is looking up to Europe, right? And I think that the specifications in China are a clear example of that. But when it comes also to interpreting what the legislation will mean, I think it's very difficult to say that the interpretation will be something like the European Court of Justice or the European Court of Human Rights would understand about the GDPR. So I think these things create layers of complexity that we need to navigate as well. I don't think it's just like, oh, it's the law, right? And it's how we wrote it. It evolves and it's understood and interpreted, right? In different ways. So I think that creates a real challenge. And issues of sovereignty as well. For instance, data localization, right? Something I didn't have the time to say, but the cybersecurity law in China has provisions of data localization. So you need to process the data locally. And that would be in contradiction with approaches, right, in other jurisdictions. So how do we reconcile that? And what's the price? So it's just for doing business with Europe, right? Of course, that is a very important goal, right? But it's one of them. Right?
And very briefly, I'm perhaps a little more skeptical about China than Marcelo. Sometimes I understand why. Marcelo knows much more about it than I do. But I would observe also, in comparison to the US, for example, no, you would not see the US government introducing a social credit system or some of the other, in quotes, dystopian things we hear about from China. At the same time, and again, as much as I am not personally in favor of data localization requirements, I do quite understand why governments faced with what we know from Snowden, the United States is doing, feel that this might be necessary and important and be willing to undergo some of these costs that you rightly talk about. Similarly, while the US government is not mandating some of these technologies and systems, the large US businesses are sort of rushing ahead with, gigantic data sharing and using not quite the sort of full social credit system, but they have a pretty developed credit record system of their own. And if you're from a disadvantaged area in the United States or don't have a very well-paid job, or as I just saw tweeted today one of 1,000 examples about insurers increasingly monitoring, social media, people's locations. As someone I retweeted said, okay, take your phone to the gym, but don't take it to the bar if you want to get life insurance in future. Don't live in this postcode if you hope to get a mortgage. There are all sorts of ways that some of these controlling mechanisms can come about. And I say this not just because I'm a GDPR fanboy. I think the more comprehensive way in Europe, I'm not saying this is how the rest of the world should do it, but considering not just the privacy-specific instruments, but the much broader human rights frameworks and constraints on state power and the private sector is really important in addressing some of these issues.
Yeah, I mean, I think to that question, I would say that I think, you can have basic principles that might be similar across jurisdictions, and I think we already see that. You have your notice, you have consent, you have purpose limitation, but when you start getting down into the nitty-gritty, I would really warn against a cookie-cutter kind of approach. I think each context is grappling with its own contextual challenges. India has a population of 1.2 billion people. A lot of those are not have digital literacy. A lot of them are using mobile phones for the first time. And so, as a government, how do they structure, the details of a consent mechanism in a meaningful way for that context? It might not look the same as something in the EU. So, yeah, that's just what I would say. Be careful about kind of the cookie-cutter approach.
Just to complement what it has said about the social credit system that you also have of kinds, right, in Western societies as well. I was attending a presentation that there was a colleague from Facebook in the panel, and Facebook has 2 billion users, right? 2 billion users. And now they need to deal with the problem of misinformation in elections. They need to deal with the problem of spread of misinformation, of fake news. And how do they deal with that? They need to differentiate who are good actors and who are bad actors. And the question I answered, and I didn't have a reply to, is how do you do this differentiation? Is there a threshold that someone crosses and someone becomes bad? And when someone crosses this threshold and becomes bad, does the person later has an opportunity of rehabilitation, right? A right to redress? So who is a bad actor? So we have the difference is that in the US you have the market dictating that, whereas in China, right, you have the government trying to instill certain values in the system, and also to curtail the power of platforms as well, which became a very dominant form of power in our time.
And I think we are going to wrap up because, yes, exactly, there is someone looking for bells. So I would thank all the panelists, and also I would thank also the participants for the very excellent questions that made us think even more about what we could do in the project and the relevance of this at this moment. So thank you very much, and enjoy probably the drinks and whatever you may find.
And thank you, Luca, for pulling this panel together and the project, and for identifying this gap in, I think, much needed and interesting research.